Please join me in welcoming Dr. Daria Boklan.
Thank you very much. Thank you very much, Lindsay, for such a long and wonderful presentation of myself. And first of all, good afternoon, distinguished guests and dear colleagues. I would like to express, well, I was thinking just to thank, as usual, to organizers for inviting me to the conference, but after yesterday's trekking into the tiger's nest, I understood that I don't know the words, the real words in English, which will really describe what I felt yesterday. And during our today's sessions, we were talking that we have to preserve this place, and I felt it by my body, soul, and mind yesterday, that it is really the place which cures you in the very moment you step on this earth. And when you spend a couple of hours here, you feel very special energy. So thank you so much for giving me such opportunity. And well, I became a different person after visiting Bhutan, and hope that I'll keep this feeling with me as long as possible. So that is the first reason for which I would be very grateful to present on this conference. The second, why I'm so delighted to present my research, which I hope finally, can you assist me with the slides? Yes. I'm sorry, it's my destiny. When it comes to techniques, to technical issues with me, it's always like that. I'm so sorry. I'm poisoned for technique. So may I ask you just yes, at least you see the title of the presentation. And then the next slide, please. Does it work? No. Oh, the next slide. Yes, thank you very much. So this research is based on this book that you can see on the screen, co-edited by my two colleagues from India and China and myself, and specific chapter of this book. And actually, this research, the basis for this research was Bhutanese Gross National Happiness Index, because this research is based on 2 out of 3 pillars out of 4 pillars from this index, namely environmental protection and economic development. And the idea is to show that these 2 spheres are interconnected, because usual approach is that, for instance, free trade objective and climate change, combating climate change objective are contradictory. Therefore, I'm trying to address this question in terms of the issue that was raised by our colleague from Japan: what particular tools, legal tools, can be used to combat climate change from the international legal perspective. And I'm trying to assess whether it is possible to use purely trade instruments in terms of international law to combat climate change. And assessing this issue, yeah, it works, thank you very much. I'm going to present this issue in the following order. First, brief introduction, then I'm going to address several questions. First, may physically identical products be considered as not like products under the jurisprudence and law of the WTO, World Trade Organization? Second, is carbon tax covered by the general agreement on tariffs and trade? Third, can general agreement on tariffs and trade inconsistent measures aimed at combating climate change be justified by a special article of the GATT, Article 20? And finally, is WTO agreement, TBT agreement on trade barrier to trade, in the context of combating climate change, be applicable? So starting with the introduction, our previous speaker, Dr. Edil, clearly explained us with respect to many facts with respect to the fact that 2020 was the warmest year on record. Being from Russia, I would like to add to this explanation that there is a coldest city in the world, specifically placed in Russia, in Russian Arctic, North Arctic, called Verkhoyansk, and average temperature in this city during the year is minus 70 degrees Celsius. So during summer 2020, there was plus 38. provisionally the highest temperature in the Arctic Circle. So we really face this process and data supports that climate change is indeed happening. So with respect to compatibility of trade and environmental issues, and in particular issues of combating climate change. On this slide you can see well-known states which are responsible for the highest amount of greenhouse gases emissions. And at the same time you can see that the same states are biggest trading nations. Therefore, compatibility of trade issues and combating climate change issues are on top of the agenda. Moreover, we know that most of the states in the world are parties to the Paris Agreement. And this agreement contains a reference to the United Nations Framework Convention, and wording of this convention shows us interconnection between trade and climate, because this convention says that measures taken to combat climate change should not constitute means of arbitrary or unjustifiable discrimination or disguised restriction on international trade. Therefore, we can see this interconnection between trade rules and combating climate change rules enshrined directly in the United Nations Framework Convention on Climate Change. Furthermore, we know that most of the states of the world are parties to the Paris Agreement. At the same time, most of the states of the world are parties or at least observers of the WTO agreement. And the only state WTO member which didn't ratify Paris Agreement is Yemen. Therefore, this means that most states in the world are under obligations of two legal regimes: Paris Agreement on one hand and WTO agreement on the other hand. Therefore, compatibility of these obligations is again on top of our agenda. Now let's move to direct wording of article of the Paris Agreement. This article contains obligations of the states, namely obligations to prepare, communicate and maintain SNDCs, and parties shall pursue domestic mitigation measures with aim of achieving the objectives of such contributions. So we see verb shall. This means that that is a strict legal obligation of the member states to the Paris Agreement. And most of such measures are closely connected to so-called PPMs, or process and production methods. And now we are moving to the first question of the presentation. May physically identical products be considered as non-like products? So let me show you a concrete example. Let's imagine that these two physically identical bottles produced with a different amount of CO2 emissions. For instance, this was produced with 0 CO2 emissions, and this was produced with big amount of CO2 emissions. Can we consider, from the legal point of view, from the point of view of law of the WTO, these two bottles as non-like products and treat them differently? For instance, impose tax on this product, which is not environmentally friendly produced, and do not impose tax on this product, taking into account that physically they're absolutely identical. So this is the question which is widely discussed within the World Trade Organization. Can PPMs, process and production method, be taken into consideration assessing likeness of the product? There are two types of PPMs, so-called product-related, so PPMs which directly physically affect the product, like smoking of fish, for instance, and non-product related PPMs. So amount of GHG emissions is a PPM of the second type. Also, the notion of like products, the term like products, can be found in numerous WTO agreements. There is no definition of a like product in the WTO. What could be helpful in this case? We should look at the jurisprudence of the WTO dispute settlement body. But it seems not very helpful because the appellate body of the WTO, of the dispute settlement, compared likeness of the product with the image of accordion. and said that this accordion of likeness stretches and squeezes in different places, and width of this accordion depends upon circumstances of the particular case. So we as the lawyers have to submit that our circumstances, climate change, are such circumstances that permit to take into account amount of CO2 emissions to consider physically identical products as non-like products. And therefore, we can submit that, in addition, according to the preamble of the Marrakesh Agreement establishing the WTO, one of the objectives of the WTO is sustainable development. Although World Trade Organization is not specifically aimed at environmental protection, in its preamble, Marrakesh Agreement establishing WTO contains objective of sustainable development. And we know that one of the goals of the Sustainable Development, Goal 13, is specifically focused on climate change. Therefore, according to the rules of international law, rules of interpretation, Vienna Convention on the Law of the Treaties, we have to take into account, when we are interpreting the term, in our case, like products, objective of the treaty. In our case, sustainable development, including climate change. Therefore, we may conclude, and this will be the first conclusion, that notion of likeness under the WTO law leaves the room for consideration of climate-related process and production method. And we may submit that this bottle is not like this one, and apply different measures with respect to the climate-unfriendly PPMs. Now moving to the second question, which is closely interconnected with the first. Is carbon tax covered by the GATT agreement? If we look at the text of the GATT agreement, it says that taxes may affect processing of the product. And in addition to this, I would agree with Jus Paulin, very famous international lawyer who specifically focuses on the WTO. He said that carbon tax, although being non-direct tax on the product, can be considered as an indirect tax applied to the products, meaning that carbon tax is covered by the WTO law. Therefore, our second conclusion would be that carbon taxes could be subject to WTO law disciplines. Moving to the third question, with respect to possibility to justify GATT inconsistent measures by exceptions. So in case WTO member applies a measure aimed specifically to combat climate change, and this measure is found by the WTO panel inconsistent, violating the GATT provisions, is it possible, according to the WTO, still to justify this measure? There are two options in Article 20. First, to submit that this measure is necessary to protect health, and second, to submit that this measure relates to conservation of exhaustible natural resource. I will focus on the second option because it is more easy for the respondent to invoke paragraph G of Article 20, which is specifically focused on exhaustible natural resource. But what first should be done by the respondent in this case? The respondent should explain and argue that climate is exhaustible natural resource, that climate as such should be considered as exhaustible natural resource. It's questionable, would it be easy for the respondent to argue that climate is exhaustible natural resource? However, we may rely on jurisprudence of the WTO dispute settlement body, according to which, namely the case US shrimps, the notion of exhaustible natural resource is not constant, it may evolve. And also, previously, the WTO dispute settlement body considered in US gasoline case fresh air as an exhaustible natural resource. Therefore, we may conclude that climate could be considered as exhaustible natural resource by the WTO panel. Then, the next step, according to this article, the respondent has to submit that the measure relates to the conservation of climate, meaning that it just has to show connection between the measure, for instance, carbon tax, and the objective, combating climate change, it would be more or less a good option for the respondent. And third tier, the respondent has to show that it applies the same measures domestically, not only applies to the foreign products. So generally, it seems more or less possible for the respondent to invoke this Article 20G to justify its WTO inconsistent measures. However, in this case, the respondent may face the same difficulties that the US faced in US shrimp case, and it may be accused that he forces other WTO members to adopt environmental standards that are essentially the same or very similar to its own standards. But nevertheless, this justification is an option for the respondent. And now finally, moving to the last part of the presentation is TBT agreement, technical barriers agreement, applicable and related to the climate change measures. According to this agreement, technical regulation may be connected exclusively with labeling and exclusively with process and production methods. And probably we all know that it is very commonly used such labels as carbon footprint labeling. Therefore, this means that all labels which reflect carbon footprint will be covered by the technical barriers to trade agreement. And that will be our pre-final conclusion, that labeling requirements are covered by the technical barriers to trade agreement, which are related to amount of GHG emissions. And our final conclusion will be that despite of their different objectives, Paris Agreement and WTO Agreement are complementary, and that most of these measures which are subject to WTO disciplines are connected with the process and production methods. And finally, WTO legal regime could be seen as one of the most effective instruments to fulfill Paris Agreement objectives. Therefore, we can conclude that it is possible to use purely trade measures to combat climate change. And this will be the final conclusion. Thank you very much for your attention.